गंगा माता की या तो खुद मरने को तैयार रहो या मारने को तैयार हो, दूसरा कोई विकल्प नहीं है.
Today we're jumping into a fascinating legal case where a single factual mistake by the government could have fatal consequences. We're going to break down a really clever legal move that wasn't about challenging a court's ruling, but about correcting the one dangerous fact that ruling was built on.
Just think about this for a second. Imagine your safety, your very life, hangs in the balance, all because you have to convince the highest court in the nation that the government is operating on bad information. It's a scary thought, right? But that's exactly the high-stakes situation at the heart of our explainer.
All right, so here's the deal. The core of the problem is this. The executive branch, the government, is refusing to protect someone from a very real threat. And their entire justification, their whole reason for saying no, rests on a single piece of information that, as we're about to see, is just plain wrong.
Now, to really get why this is such a big deal, we have to talk about Article 21 of the Indian Constitution. This isn't just some dusty legal text. It is the absolute bedrock of fundamental rights. It guarantees your right to life. So when the government's actions, based on a simple mistake, put that right on the line, you're looking at a serious constitutional issue.
So you'd think, okay, if a court order is being used the wrong way, you just file an appeal, right? Seems like the obvious next step. But in this case, that was exactly the wrong way to go, and understanding why is really the key to the whole strategy here.
And you know, the Supreme Court itself had the very same thought. They essentially asked the lawyer, hey, why are you here with a whole new petition? Shouldn't you just be filing a special leave petition, an SLP, which is the normal way you'd challenge a previous court decision? It's a totally fair question.
And the lawyer's response? It's just perfect. So precise. They basically said, look, we're not here to argue about the court's past decision. Our problem is happening right now. It's about the government currently using that old order, an order based on a factual error, to violate my client's right to life today.
This slide really lays it out beautifully. A standard appeal, the SLP, is kind of like taking a sledgehammer to the old judgment, trying to tear the whole thing down. But this constitutional remedy, using Article 32, is more like a scalpel. It doesn't attack the judgment itself. Instead, it surgically cuts out the government's factual error, stopping them from misusing the judgment.
And that brings us to their brilliant move, this constitutional surgical strike. It's a direct plea to the Supreme Court, not in its role as a court of appeal, but in its most important role, as the ultimate guardian of our fundamental rights.
So what exactly is Article 32? Honestly, you can think of it like a constitutional emergency hotline. It's a special power that lets any citizen go straight to the Supreme Court when their fundamental rights are being violated. It's a shortcut, because when a right as basic as the right to life is in danger, there's simply no time to waste.
And this is the key takeaway, you know? The lawyer isn't asking the court to rehear the whole case from scratch. The argument is way smarter and simpler. They're just saying the government's entire reason for denying protection is built on this one provably wrong fact. We're just asking you to step in and correct that foundation.
Okay, so making a bold claim like that is one thing, but proving it, that's a whole other ballgame. This entire strategy, everything we've talked about, it all comes down to whether they can produce the smoking gun, that one piece of undeniable evidence.
So the court, quite rightly, puts them on the spot. The government's whole argument rested on the claim that the petitioner never actually reported the threat to the senior superintendent of police. So the judges say, all right, where's the proof? Show us you actually went to the SSP.
And boom, this is the mic drop moment in the courtroom. The lawyer simply points the judges to a specific document in the file, Annexure P6. It's not a letter, it's not a verbal claim, it's an official police record, a diary entry, from the SSP's own office, complete with an official seal and endorsement.
And this one piece of paper just demolishes the government's entire argument. It proves 4 crucial things. 1, the petitioner absolutely did go to the SSP. 2, their complaint was officially logged. 3, it was even forwarded for action. And 4, the big one, the state's central claim was completely factually wrong. Game over on that point.
So, with that fact now nailed down, the argument pivots. The lawyer isn't even asking for the final win just yet. The request is for something much, much more urgent: immediate protection for their client while the court figures out the rest of the case. And the request is laid out as this simple, logical 4-step process. First, just acknowledge this official police record is real. Second, follow your own rules on threat assessment. Third, based on the real facts, provide protection now. And fourth,
In doing so, you'll be safeguarding this person's fundamental right to life.
So after all the complex legal maneuvering, the ask is incredibly simple and powerful. It brings us right back to where we started. It says, forget the legal arguments for a second. Just look at the facts, the real facts, now proven on the record, and protect a human life. It's a plea for the state to do its most basic job.
And that really leaves us with a final, important question to think about. This case was a masterclass in legal strategy, for sure. But it's also a stark reminder of a deeper truth. How many injustices out there don't hinge on some complex legal theory, but simply on getting one basic fact right? It's definitely something worth considering.